We'll now hear from our first speaker, Mr. Joseph Torres, and followed by Mr. Alvin Velasquez. Joe, how are you?
Good, Chairman. How are you?
Just great, thanks.
Thank you. My name is Joseph Torres. I'm a partner in the Labor and Employment Relations Department of Winston & Strawn, based in their Chicago office. Chairman Pierce, members of the NLRB, thank you very much for the opportunity to address the Board today regarding its proposed election rule changes. This morning I would like to address the Board's consideration of permitting the use of electronic signatures to satisfy the showing of interest necessary to file a petition. This proposal should not be adopted because it will increase the risk of false or inaccurate showings of interest, given the well-documented ease by which e-signatures can be manipulated and misused, and given the limited facial review that the Board permits of material submitted by a petitioner. As the Board noted in its notice of proposed rulemaking, one of its obligations is to ensure accurate vote determinations. That obligation does not only begin when the first ballot is cast, and it cannot take a back seat to any policy considerations the Board might believe will promote more expeditious resolutions of questions concerning representation. Current policy prohibits litigation regarding the adequacy of a showing of interest, and current policy also limits the regional offices to conducting no more than a facial review of that showing of interest. In addition, the collection of signatures that petitioners present in support of a showing of interest occur in an unregulated and unsupervised process. Given this backdrop, permitting any type of electronic showing of interest would further degrade the existing minimal safeguards currently in place. And any purported ease that permitting such showings of interest would provide to employees or labor organizations is far outweighed by the further reduction in credibility that would attach to the Board's election procedures if showings of interest based on e-signatures were permitted. Each day brings additional press reports regarding how electronic commerce is rife with intended and unintended misuse of electronic information. While e-commerce may be a natural and inevitable consequence of our global economy, it provides no support for permitting employees' fundamental rights under the National Labor Relations Act to choose to engage in or refrain from engaging in protected concerted activity to be put at risk for misuse from intended or unintended manipulation as part of the Board's election process. Any type of e-signature carries these risks. A responsive email that an employee signs by including his name, reproduction of physical signatures, and electronic acceptance where an employee clicks to signify acceptance. Equally problematic is the numerous mediums, websites, e-bulletin boards, Facebook pages, etc., by which requests for support can be requested and transmitted. An example of these concerns can be found in a recent court decision that refused to enforce private arbitration agreements that employees in question electronically accepted. In that case, the court declined to enforce the agreement because it found there was no evidence of any security around the passwords employees used to enter the site. There was no evidence of processes in place to restrict access to the screen where an employee was deemed to have accepted the agreement. And there was no process in place to verify the authenticity of the signature, and no evidence that the employee in question actually opened the email and accepted it. Given all of these potential issues, there's simply no reasonable way to ensure that the electronic collection of showings of interest can be conducted in a manner that does not raise serious questions about the integrity of the process, particularly given the limited oversight that the Board policy provides for that part of the election procedures. These risks far outweigh any of the purported reasons cited by the Board in its notice of proposed rulemaking. The Board cited the Government Paperwork Elimination Act, and while I'm sure we all agree that reducing the tidal wave of paper engulfing the federal government is a laudable goal, requiring e-signatures in that circumstance is distinguishable because in those circumstances there are safeguards attendant to submitting information to the government that are not available in the private gathering of e-signatures. The Board also cited the Signatures in Global and National Commerce Act, and again, e-commerce occurs in a regulated environment where the ability to detect and challenge inaccurate signatures can be addressed by the parties to the transaction. No such checks and balances would apply in these instances. The Board also cited its own advances in providing for e-filing and issuance of decisions and remedial notices electronically, and none of those laudable advances provide any parallel support for e-signatures in this instance. E-filing and electronic service of pleadings carries compliance with ethical obligations or sanctions for misuse of those systems. While embracing technology is laudable, the board in this instance should not embrace possible technological advances where the potential risk degrades the ability to ensure accurate vote determinations. Thank you very much.
Joe, what about the security piece? Suppose a proposal provides the security that was suggested existed in government e-filings, like the filing of e-signatures for taxes and e-filings in the courts. Would that resolve the issue?
I'm not sure how you could mandate those types of processes onto a private party. I think that's the problem. I mean, if you've got organizations and individuals out there soliciting signatures, it's hard to imagine how you could fashion a system that could consistently ensure that all of those solicitations are occurring through some process that might be used where there's a unified portal for individuals, for example, to file petitions with the board, to file a complaint with the federal court. I just don't see how the board could impose that type of process in the myriad of instances where individuals are being solicited to sign authorization cards.
Okay.
Yeah, Mr. Torres, there's a significant array of financial transactions that's done currently electronically. Is there anything special about showing of interests that you think would require a different treatment or counsel towards a different treatment?
Well, again, I think that the parties to a financial transaction have the ability to look at both sides of that transaction if there's an issue regarding the validity of that transaction. Here, the employer who's being subjected to the petition has no way under the current board policy to say, well, wait a minute, I've got a question as to whether or not this transaction was actually legitimate. And the board has made a determination that they're not going to permit litigation of those issues, and they conduct a very limited facial review. So I think there is a distinction there as to a financial transaction where both sides obviously can, if necessary, get to the other side of the transaction to see what actually happened.
I wanted to bring up a few points. In the 2014 comments submitted by the AFL-CIO, which you may or may not have had a chance to read, there's a piece on there about electronic signatures where the suggested proposal is basically that the the employee provides their home address and phone number and some sort of indicia of signature in an email. The union confirms back to the employee in an email, thereby getting their consent. Essentially, we're going to use this as an electronic signature. That gets forwarded to the board agent. Then the board agent is able to call up the employee at the phone number, and to the extent that there's a personal email address in there, can email them back and then verify that. Would that satisfy you in terms of the checks and balances that you're envisioning?
Well, I think there's two points there. One, I think the board would have to modify its current policies because in the current instance, the board has to accept at face value that what's being provided to them is legitimate. So that would require a whole new level of oversight. Second, the cost associated with the board physically calling people in, let's say, a 2,000-person bargaining unit I just don't know that administratively the cost and expense is going to be manageable. I just don't see the board dedicating those sorts of resources to this and given the thousands of petitions that are filed, I just don't see that to be a workable solution.
Well, do you think that would be able to smoke out mass fraud, though? And because if you go back to the cases like Bakelite in the 1940s and H.G. Hill, where the rationale was first advanced for the no collateral attack rule, the point of the rule was basically like, look, we just simply want to safeguard against frivolous proceedings. We don't want to have indiscriminate institution of representation proceedings by parties who have nowhere close to any employee support. Assuming that that's what our rationale is, A, why can't that be satisfied by the procedure suggested by the AFL-CIO? Or B, do you want us to open up the no collateral attack rule so that now the respondent will have a chance to basically attack the showing of interest? Because as the articles that you cited by Dr. Lopez Hernandez Ardieta suggested, that basically we have to go behind the evidence here and see if it is really evidence of non-repudiation, as he says.
Well, given all of the numerous ways in which the professor notes that e-signatures can be manipulated, I do think that if the board is going to allow a process where the regional offices are going to start questioning the means by which things are being transmitted, it would be only fair for employers to have an ability to look at that process and evaluate whether they believe it's being done in some proper manner. And again, if the board is going to really go down that road, I don't think you can just, on the one hand, open up the process for the regional offices and still preclude employers from being able to comment on that process, given the numerous ways that the professor indicates that these processes can be manipulated.
But he doesn't say that it is an impossible proposition to rely on electronic signatures. He basically says the reliability of a signature as evidence in a legal proceeding will highly depend on the capability to find and prove the existence of a vulnerability in the process. And so if we had that capability, it seems like that would remove your objection.
Perhaps, but again, I don't think that you can only have half a loaf in that instance. I mean, you're leaving it. You're tying the hands of employers to just accept that whatever processes the board decides to adopt to check on these beyond simply a facial showing is adequate. And I think the professor's point is that there are some mutually acceptable means by which the parties are verifying that the signature is acceptable, not just a unilateral process that one party decides to propose and declare to be acceptable.
One last piece. You agree that the digital signature standard supported by the Department of Commerce in 2013 would be adequate enough to show an electronic signature?
Subject to verification, yes.
Okay.
There's a lot of technology, and certainly technology has, in leaps and bounds. I know I almost never sign my signature on anything anymore, and there's a whole variety of ways, and I have no idea what the verifications are when I sign it. I don't verify what they're doing on their end of it. And sometimes I sign it, and sometimes it's a click, and there's a lot of different ways. But as the technology moves along, doesn't it seem to not contemplate the possibility of using technology in this area as well? Puts us back to where the Act was first drafted, and we still have in the Act that service can be made by telegram?
Well, it certainly is that technological advances provide opportunities to streamline and make things more efficient, and all of us are perhaps every day knowingly or unknowingly signing things electronically. The point here is, though, that we have a process that in its current framework is unregulated largely. And so all of your ability to verify, if questioned, the validity of your signature allows for a bilateral process. And that bilateral process currently is not permitted under the board's rules. And so to the extent we embrace technology, as I was saying to Member Miscamera, there typically is a bilateral ability to challenge and check on whether those signatures are valid. And it may be 20 years from now or 30 years from now we're at a place where the strength of those types of submissions are even less subject to manipulation. But just seeing what happened with the major retailers over Christmas shows you that the amount of mischief that can happen with respect to electronic transmissions suggests that we are far from a place where these processes are safeguarded enough that we could assume that an unregulated process could occur without any real risk of there being some manipulation, intended or otherwise.
Thank you, Mr. Torres.